All right, everybody. So today, Katie and I are going to be looking into the Roncker on behalf of the Roncker versus Walter case. Roncker is the parents of Neil Roncker. He is a 9-year-old student, and then Walter is the school district that he was in.
So basically, this case was between obviously the school district and the parents because Neil was diagnosed with TMR, which was traditionally referred to treatable mentally retarded, which is now obviously a severe intellectual disability. So although his chronological age was the age of 9, he was more functioning at the age of a 2 or 3-year-old. So in an IEP meeting with the school and the parents, it was decided that Neil would be placed into a specific school with other students that had similar intellectual disabilities as he did. However, in a past evaluation, the parents were told that Neil would benefit from interactions with his non-handicapped peers, so they fought the school on this decision.
So that placement, or that evaluation, occurred in 1976, and then in 1979 is when that IEP evaluation happened that Katie was talking about. Here is where the school district decided to place him in a county school, so a school specifically for students with severe intellectual disabilities. And at the school, Neil was not going to have any contact with any neurotypical or non-handicapped students. So then later that year, according to their parental rights listed in IDEA, Neil's parents, or the free appropriate education, Neil's parents refuse that placement and seek a due process hearing. And in this hearing, the officer agreed that the placement was not appropriate and ordered Neil to be placed in a different setting within that elementary school. Now, the kicker here is that he decided, meaning the hearing officer, ordered that they would have to go to the school and have a split placement service, but they didn't outline very many details other than the fact that Neil was going to be at a school that had both neurotypical and students with intellectual disabilities, and that Neil, or the school at Pleasant Ridge, allowed for the intellectual disability students to have time interacted with lunch, gym, and recess. Sorry. Then, so Neil started attending that school in September. A few months later, in January 1980, the parents had let a few months go to see if they liked the school or not, and they decided that they still did not like or agree with that placement. And so Neil was Neil was taken to court again about his placement. And it wasn't about if he should receive instruction with them, but it was about the different levels of interaction. And then finally, in February of 1983, the district court rules in favor of the school district. Now, something important to remember here is, according to a lot of the cases we've looked at, the school has not been the one to win in the end. Usually it's the parents, but the school district found, or the district court found, that the school was correct in their placements, and that his level, or his disability, was to the point where he needed more severe help, and that the placement, or the class action that the parents went through with, was actually inappropriate because of the needs that he has. Oh my goodness. There.
Okay, so the holdings for this case, there was multiple holdings that were made during the due process. However, the final judgment was that the district court was that Neil's placement in a specialized school satisfied the requirements for the section of least restrictive environment. So we have to remember that the act, the Least Restrictive Environment Act, does not require mainstreaming in every case, but the requirement of mainstreaming to be provided to the maximum extent appropriate indicated is like a strong preference. However, when Neil was in the school with his non-handicapped peers, they found that he had made no significant progress in the 18 months that he had been there. So that kind of led to the court's decision that he would be better off in a more specialized school so that he could have some more educational progress as well. So with the rationale, that obviously was a huge part, the no progress, but the school also looked into how a lot of times people think that least restrictive environment means the least time spent in the special education classroom. And this was a new law at this time. But they also then argue that some handicapped children simply must be educated in a segregated facility, either because the handicapped child would not benefit from mainstreaming, because any marginal benefits received from mainstreaming far outweighed the benefits from getting services that could not feasibly be provided in the non-segregated setting. So these were kind of some of the rationale that went into the court's decision of having Neil be placed in the specialized school.
A couple of the summaries that we found on one of the websites was talking about the different importances of this case and how they looked at it from a different perspective. And one of them was specifying that it was not the methodology, but rather if the act was actually being required that or being satisfied with this case. And that is something really important to look at because the parents knew that he could not receive the same education as those his age, but thought that he needed more interaction with those students. And then another thing, that mainstreaming requirement, is what Katie just talked about. And then that last one is the summary that I really appreciated because it says that sometimes we think about one placement as superior to the other, but that's not necessarily the case. We need to remember that all of our students, no matter what, need to make that progress, and whatever placement allows that progress to take place is the placement that is the most important. And in the case of Neil, he was not making any progress in the mixed placement setting, and so that is what was important. And that is where we went and found the placement continuum. And I thought this was super cool because it shows the different degrees of placement, that some students truly can't have that general education with no aids. Some students need that self-contained placement, but then we also have to look at there's so many more even past a self-contained in-school placement. And so I just thought that that was super important because I don't feel like we always talk about that. And we talk about how to get most of our students into that general education classroom, mostly because we are a mild to moderate program. And so that is important to remember in our settings.
So our discussion question is kind of a two-parter. We thought it was really important to do it this way because this case did side with the school's decision, which doesn't happen very much. So our question was what processes do you think are most important for determining the least restrictive environment placement for your students? And then if a parent questions this placement of your child, how would you defend your decisions while also taking their concerns into respectful consideration? So that is the end of our little slideshow for you. We had a lot of fun researching this one, and I think there's a lot of good information in here that we can learn from and take into our least restrictive environment and placements in the future.
I look forward to looking at your responses. Thank you, guys.